Welcome back to the Endeavors AI podcast. I'm your host, Colin McKee, founder of Endeavors AI, where we talk about the intersection of artificial intelligence, law, business, and the new economy being built all around it. My guest today, Spencer Days, on the exact problem most business owners don't likely know that they have yet. Jennie Woltz is a labor and employment attorney with about 2 decades of experience in the field. She co-founded her own firm, Woltz and Folkinshteyn, and she advises employers across New York, New Jersey, and Connecticut on the unglamorous stuff that decides lawsuits, like handbooks, leave policies, hiring practices, performance reviews, and the like. Here's why I wanted to have her on. The HR team, your HR team, is likely using AI today, and the risk isn't that it writes something wrong, it's that it writes something that looks completely right and is quietly missing the important part that might keep you protected. Jennie, welcome to the show.
Thanks so much, Colin. I appreciate being on.
So before we get into the AI piece, I want to start with you because you built something I think is genuinely unusual in law. You built it before AI was a part of the conversation at all. And so give me the 2-minute version, if you would, 20 years in employment law, and then you go and start your own firm. What made you do that and go out on your own?
Great question, Colin. So I saw from working both in and out of large firms and in the nonprofit area that there was a huge need for someone who could come into businesses and help reduce employee drama, streamline HR, and give people the quick, speedy advice they needed at the price they could afford to make sure that their workforces stayed drama-free and risk-free from lawsuits. And I just felt that was a really important goal, and it was something that I really wanted to help to help people with and help the world with. So together with my partner, we formed our own law firm. It's very much it's very much built around the idea of providing proactive advice, counsel, and solutions that help prevent the lawsuits before they get started. And then, of course, we do all of the regular things that a law firm does, such as defend and prosecute as we need to claims to keep employers risk free. We want to keep the workplace overall. We want to keep the workplace a dignified place to work for everybody, whether you're an employer or an employee.
Awesome. So let's go into a little bit of the details of what makes this unique. During COVID, you built an employment law co-op. So walk me through that. What's happening during that time? Who's calling you? What was the catalyst that really made you think that the hourly model wasn't going to work for them?
Yeah. So during COVID, as everyone here can remember, the world that we lived in was rapidly changing. I mean, the idea that we're doing this interview over Zoom is just one such artifact of that. But the workforce in particular had so many changes happening between masking laws and vaccination laws and new sick leave laws that things, especially in the tri-state area where I practice, were changing constantly, and employers had so many questions. And a couple of my clients came together and asked me and my partner, who's also my husband, Ben, if we would consider doing a regular weekly or bi-weekly seminar for them just on the changes so that we could help their HR departments stay really up to date and present on those ever-changing laws and deal with those issues as they were coming up in real time. And what started off as a very collaborative group of a couple of employers pooling their resources and getting some real boots on the ground practical legal advice ended up blossoming into what we do now call a co-op of legal services. And we now have 11 or 12 different employers who are part of this co-op, this employment law co-op. And what happens during this co-op is that employers can come to us with any sorts of day-to-day questions, and there's a joint representation agreement. We try to keep the questions anonymized, but we will share the questions asked and the solutions presented so that the 12 employers can get essentially 12 times the legal services for the price of one.
So dig a little further into that, because this is a new topic for this show, probably for most of our listening audience. How does the joint representation agreement actually work? Because I feel like a lot of people think that it wouldn't, but you've made it work. So how does that agreement work?
Yeah. Well, everyone knows who's part of the co-op. So they know that if they hear a question that I'm presenting to say, hey, one of you asked this question, they know that it's one of the 12, right? It's not an anonymous person. It's a real life situation that some other HR person within this group had. And the joint representation says, listen, this is privileged for all of you. And again, when we try to present the topics, we won't say who it is, but inevitably, in a group setting, there'll be one HR person who'll say, "Oh, that's my question." And so everyone, people keep it confidential as if it were their own.
It's great. Yeah, it makes perfect sense. It's just outside of the norm. So a lot of people wouldn't go there defaultedly. So another thing that jumps out at me for this is that it's been growing annually, year over year for you. So it's obviously working and it's something that's a real demand and real value for your clients. What was the moment, or was there a moment where you realized that clients weren't buying your hours anymore? They were buying solutions. And, that was that the cause of the catalyst to change?
So good question. I want to be really clear. We have plenty of clients who still pay us hourly. Although I will say that many clients have also wanted to start saying, they're interested not just in they don't care how long something takes. They want a solution. They want something that's more value based. And there are certain kinds of projects that lend itself to that very well. If we're redoing a handbook or we're doing some kind of a discrete project where there's a clear outcome, there's a clear deliverable, it makes sense from all perspectives, right, to get some cost certainty. The last thing clients want is to be surprised by a bill they weren't expecting. And if they can get the value and we can all agree on a price, then that's good. But the other thing that I think that working on a fractional basis, or on a subscription basis over a long period of time, is it's one of these things that once employers have it, they realize how much they how much they need it and how much they don't realize they don't. And reducing the friction, and this is one of the biggest benefits, is if you've already paid for something and you've got a subscription, it reduces that friction. So HR has no reason not to call you for a question. You as the counsel. And so you as HR can make, and as the employer can really rest assured that all of the decisions that are being made day to day are helping your business, be quicker, more efficient, less drama free, more consistent, and then you're reducing risk while you do it. So it's a benefit to everybody. And when you're paying hourly, there is a tension between bettering your business and feeling like it's going to affect your bottom line, but you don't have that same concern when you've already budgeted for these kinds of preventative legal services.
Awesome. So it's a great segue. You said a couple words that stick to the next topic is decision, benefit, and liability. And so in the topic of AI, a lot of people think that they need to make a decision on how to use it, but likely a decision's already been made and people are using it, and they're looking to implement it to cause efficiencies and to avoid liabilities. So let's get into those terms, because most likely, everyone's HR person or the department is using a chatbot of some sort of way, right? It's just not necessarily in a policy. It's not structured just yet. So give me some real time examples that you're seeing where people are actually finding AI show up in their HR functions and they're surprised by that. And when, people don't realize that there's legal consequences to it. That's kind of the meat of our discussion. So if you can give us some examples of where AI is just popping up out of nowhere and what liabilities it might be causing.
Yeah. So 100% what you said. And you said something at the beginning of the episode too, which I thought was really important, is that AI ends up creating this sense of certainty with whatever you're doing, and it just simply isn't there. So where are we seeing this in HR teams? We're seeing this in a couple of different places. The first place we're seeing this is in adopting systems that use AI to screen applicants. And there's actually a very direct potential legal liability in all of these screening tools that several states have actually started to address and legislate. So if you're in a jurisdiction that has an AI screening tool law, you obviously are wise to look up what that law is and make sure that you're using that screening tool correctly. What are some of these laws that are in, for instance, in New York? Connecticut, a couple of other places where they basically say that either an AI tool, and they're different in the different jurisdictions, but it either needs to be disclosed to the candidate, it needs to be vetted for discrimination risk, or it needs to be not the 100 solution for screening. There needs to be a human behind it. And sometimes it's all three. And so I think screening tools is one of the biggest immediate risk that HR right now is using AI, and it could lead to some pretty bad, some bad problems. The real concrete risk there is if you're using an AI screening tool and it's creating a disparate impact. Your screening tool, for whatever reason, is only selecting people of a certain race, gender, color, creed. There's no defense. There's no legal defense to say, well, it was just the screening tool, it wasn't me. You are responsible for all of your AI tools. The second place that we're seeing AI come up quite a lot is employers trying to use AI for legal or quasi legal documents, such as handbooks or contracts. And while, as you pointed out, I might come up with something that looks good. Just because something looks good doesn't mean it's legally compliant with your jurisdiction, your employer makeup, or that it doesn't have gaps. And that's oftentimes because you can put into ChatGPT or Claude, you can say, hey, make sure that this is a handbook that complies with X, Y, and Z, or a contract that complies in this jurisdiction. And so it might be right, but it's not complete. And inevitably, even when I'm using AI tools in my own practice to help, to get the ball rolling on drafting and stuff like that, it's really it's really looking at the chess move, three moves down. What's going to happen if this other thing happens? What happens if this risk is there? Is the way that this is drafted actually protecting me, or is this just a generic clause that was put in there, right? ChatGPT, Claude, they all make assumptions about what you as the drafter want, and they don't sometimes know they're even making those assumptions. So there's a lot of incompleteness. And to be fair, even before AI and ChatGPT, you had mentioned, and it's true, one of the things my firm does is we review handbooks for compliance. And we used to see all the time employers would take templates from their friend's company or something they found on the internet or whatever it was. And we would find, here's a really great example, a tiny employer who would have an FMLA policy, but FMLA doesn't kick in until you have 50 employees. Right. So, sometimes things would be in there that didn't need to be in there. Sometimes things would be in there that weren't sufficient. Employers would say, well, this is the way we do our PTO policy. And we'd have to say, but there's a sick leave law that guarantees X, Y, and Z. Anyway, the point is that even before AI, if your HR team doesn't have the judgment of what needs to be in that handbook or not in that handbook, and you won't get the results you want from AI. And this is especially important when it's not just handbooks or employee-facing policies, but contracts, which of course are meant to be written in the event they need to be enforced in a court. The third area I think that we're really seeing a lot of AI use is in general employee communications. And good HR people know that every employee communication could at some point be Exhibit A in the future lawsuit of how HR failed to let you know about a leave right, failed to escalate something appropriately when you complained, failed to give you proper information, or a number of different things. So good HR people recognize that every email that gets sent could truly be an exhibit later. But when HR people are just trying to manage their inbox of 150 emails a day and respond to people, and they're using AI tools to quickly respond to the issue, they will miss larger picture issues, and they may not be saying the right things. So too quick use of AI to respond without using real knowledge and an insight of what the overarching picture is, what the overarching concern that employee has, can end up creating a lot of missed opportunities to, for instance, make sure the employee is being offered the leaves that they're entitled to, make sure the employee is that you're starting your interactive process if an employee has mentioned need for time off or some kind of disability. It's really reading between the lines. That's the art of HR. And AI doesn't have that same judgment that a seasoned HR person and certainly an employment attorney who can see the lawsuit waiting to happen has.
Yep. Yeah, in our first call, you likened it to an 80-20 rule that AI can get about 80% of it spot on, but there's that 20% that it might fill in or, it's going to look right, but it's that 20%, right, that can get you into a lot of trouble. And you already covered it pretty well, but I mean, why does that 20% need so much focus from a professional? What are the levers? I don't know. I don't want to answer my own question here, but that 20% that gets into the intricacies like you mentioned with the FMLA or whatever, makes it quite obvious that, you didn't really do your research or you didn't have guidance to do this the correct way. And it can really get people in hot water. So I think that's what you're trying to encourage people to really focus on to make sure that they've got the particulars and run through, the entirety of it, the 80 and the 20 to make sure that it's appropriate for their business, right?
Right. Yeah, no, I mean, the 20% that you mentioned, I mean, that's why you're hiring a professional is to be able to see those things that maybe 80% of the people don't necessarily see. You want that expertise in your business because you don't just want to be middle of the pack, right? You want to be seeing, ahead of time, ahead of the, you know, sorry, I'm messing up
Yeah.
the phrase here. You want to be seeing around the corners, and it's that 20% that AI is not seeing around the corners. What AI does is it takes what's out there already and averages it, right? It's not looking it's not able to take a look and say, most people are not, and they're not looking at what the case law is. They haven't been to litigation and have to defend their decisions against a jury and against evidentiary standards, and using someone who has been there and has seen it and can anticipate those risks and then better set you up for success is really where is where a lot of the art comes in. you know so that's does that answer your question?
Sure. Yeah, and it definitely
Yeah.
does. And another thing, just to coattail on that, is that the AI can do it if it's given all of the proper guidance from a topic expert, but
Yes.
if you don't know what to ask, then the AI just grabs at, whatever to fill that space. So,
Right.
one like Jenny, she could probably use that tool and ask it all the right questions and make sure that it's covered. But for the layman that doesn't know all of the case law and all the, the ins and outs and intricacies of where, what the new laws are being written at that can leave you rather liable, you could find yourself in some trouble. So, business owners listening to this, we don't want to scare you, don't mean to scare you, want to bring you information, but you're right, right to be nervous and want to address it. So let's kind of talk to that topic. If I'm a business owner and I'm trying to stop my team from creating these liabilities for me, I'm not going to be able to tell them, hey, don't use AI. Ship has sailed, everyone's using it. But what can we do to be responsible with our employees to actually have responsible AI use? What does that look like for a firm, or what do you recommend to your clients since this can be a quite, a cause of liability for them?
Yeah. So my advice to firms is a couple of different things. First is accept that your employees are using AI and have an AI use policy. One of the things we actually didn't talk so much about on this call is not specific to employment law or litigation at all, but employees using AI behind the scenes, if it's not firm sanctioned, they're likely putting in your company's trade secret information, your details into some free ChatGPT or some, unpaid Claude subscription, and who knows where that's going. Have an AI policy, accept that people are using AI, ask them how they're using AI, put limits on it, and make sure that they're not putting your business's confidential trade secrets, confidential client relationships, things like that, into some box that you have no control over, right? So have a policy. That policy should dictate how people should use AI. So I think that's the number one thing. The second thing is, right, get clear on how people are using AI so that you, as the employer, can identify what sources of risk are happening. If your HR team is using AI to communicate with employees, right? In what way are they using it? Are they using AI to substitute for their own judgment? Are they relying on AI really as a false sense of security that you need, that you should have the true expertise, on before you're using that for things. Are you adopting new technology? Going back to one of the risks I mentioned earlier with some of these AI selection tools and the AI selection laws. If you are using any kind of AI selection tools in your business, check. See if there is a law that directly affects that tool. And even if there's not, it's best practices. Audit that tool and make sure it's not creating a disparate impact risk for your company. Disparate impact again is the idea that you can have a tool that's that has some internal bias in it. And surprise, surprise, if you are using your existing workforce's data to influence your AI decision making tool, there is some bias in there. I don't know what it is. I can't tell you sitting here if it's good bias, bad bias, or not. But you should have it audited and make sure that you are not perpetuating biases that already exist in your workforce.
Yeah, it's great advice. I mean, and good for you. You got to this topic a beat before I did. That was actually going to be my next question. But yeah, I mean, use the tool for what it's worth. I mean, no one wants to dig into the terms and conditions of everything that we click yes on, but when it comes to, your sensitive information for tools that you're using for your workforce, it's worth it. It's worth scanning it and, giving the tool your municipality to know what your local laws are, rules are per state. It's an easy, and it's a perfect use of these tools. That's what that's what they're designed for, to do that tedious work of large, document review for us, just to cover your own butts. And another thing that a lot of people haven't put into place, and that the discussions are starting to happen, is that AI AUP. You've got an acceptable use policy for everything else, and this is coming down the pike. So it's very important to get that out to your staff, so they know. And you'll have one that's designated for legal or confidential information, and then they can use the non-confidential information in their own private chatbots and things like that. But to have that delineation is super important. Very, very good advice. Appreciate that.
Yep. I have one further thing, a really strong piece of advice that came from a recent case, and I should have remembered it 30 seconds ago. But this is also an important thing. There have been cases recently where people's use of AI has been discoverable in litigation because an AI is not a lawyer. And attorney-client privilege only protects communications you make to a lawyer. So even if you're writing in AI, hey, I think I have a claim for X, Y, and Z. Tell me, do I? Or do I have this workplace problem? Right. And this can happen on the employer side, it can happen on the employee side. Those communications are not privileged. So that's another risk that I think is important for all employers at this point in time, especially those in people in HR and in legal, to say when you're be really careful about just kind of brainstorming on your own, making sure that your communications are protected. Otherwise, that the whole chat history could be discoverable, and you could lose some important leverage in a later litigation.
Great point. Thanks for bringing it up. All right. So, a couple of questions before we close out. One thing that you could give advice to any business owner this week to do to protect themselves from everything we've talked about.
Acceptable use policy. Make sure your staff actually knows what they're doing before using AI in their own subject matter jurisdiction, and make sure that you have the resources to get truly specialized and expert advice when you need it.
Where do you think AI and employment law is headed in the next 2 years, in your honest read?
Hmm. I think that AI is going to get better. It's going to be trained. I think that a lot of leave administration. I do think more contracts are going to be a lot quicker. That is where I think that policies are going to go to go the route of AI as well. Yeah. I think we're just going to see more of it. I think one area we didn't really discuss today, employee complaints. A lot of employee complaints, we're seeing people are using AI to make their complaint seem more important than it is. So I wouldn't be surprised if we're seeing more complaints being generated from AI. But again, in the same way that there's the risk of, just because you're using AI, something might sound really good. Just because an employee is using AI for their, for a complaint, doesn't mean that it has any more teeth than if they were speaking it in their own words. But I do think it's going to people out a little bit more when they see something that looks so polished and professional, even if there's no substance under it.
Use it for good, bad, and ugly. So
Exactly.
expect it to come from all angles.
Yeah.
And lastly, where can people find out more about you and follow your work?
Great. Well, we have a website. It's www.wfpclaw.com. I'm also, I'm findable on LinkedIn, and those are really the two best places to find us.
Awesome. We'll leave links in the show notes. So I really appreciate it. I think the 80/20 rule is something that people can marinate on, and the sound advice for business owners to start to look at an acceptable use policy for all their employees is very valuable. And I think everyone should take it back and apply it. So if you're listening and you're wondering if your own firm or business, where you stand in AI, whether you're exposed or behind or ready to move forward, that's what Endeavors AI does. We like to peel back the layers, kind of get a good full view and audit your business to see where things can be of benefit. And like Jenny's bringing to the fore, do it in a way that's responsible and doesn't create liability, but just creates the efficiencies that you're looking for. So reach out. Our website is endeavorsai.com. And once again, I'm Colin McKee for Endeavors AI. Jennie Woltz, thank you for being here, and we will see you on the next episode.
Thanks so much, Colin.
Awesome.